Chapter 6 of the South African Law of Persons, 6th edition by Jacqueline Heaton. The topic of Chapter 6 is minority. Under Chapter 6 we have 6.1, the introduction, 6.2, children's rights, 6.2.1, Constitution of the Republic of South Africa, 1996, 6.2.2, Children's Act 38 of 2005, 6.2.3, United Nations Convention on the Rights of the Child and African Charter on the Rights and Welfare of the Child, 6.3, the legal status of an infant, 6.3.1, capacity to act, 6.3.2, capacity to litigate, 6.3.3, capacity to incur delictual and criminal liability. 6.4, the legal status of a minor. 6.4.1, capacity to act. 6.4.2, capacity to hold certain offices and perform certain functions. 6.4.3, capacity to litigate. 6.4.4, capacity to incur delictual and criminal liability. 6.5, termination of minority. 6.5.1, attainment of the prescribed age. 6.5.2, marriage. 6.5.3, veneer aetitis and release from tutelage. 6.5.4, emancipation. These topics are contained from page 85 to page 118. And just before we start, thank you so much for listening. Please take a few seconds to like this and previous videos if you found them helpful, and please also subscribe to our channel, The Helpful Voice. Thank you. 6.1 Introduction. Minority is one of the most important factors influencing a person's status. The legal view is that because people's juristic acts are dependent on their expression of will, only persons who have a reasonable understanding and judgment should have capacity to act. In other words, the law confers capacity to enter into juristic acts only on persons who can understand the nature, purport, and consequences of their acts, since such acts may have far-reaching consequences for their authors. For example, they may result in the creation or loss of rights and duties. Obviously, youth has a major influence on a person's power of judgment. For this reason, the law protects young people by limiting their capacity to participate in legal interaction. From a legal point of view, the starting point is that a person has neither the intellectual ability nor the experience to participate independently in legal and commercial dealings before reaching the age of 18 years. The restrictions on a minor's (see footnote 1) capacity do not violate the constitutional right to equality because their objective is the minor's protection. See footnote 2. Generally speaking, a person acquires full capacity to participate in legal interaction on his or her 18th birthday. See footnote 3. However, several earlier ages are of legal importance. For example, children below the age of 7, that is, infantes, have no capacity to act, while minors between the ages of 7 and 18 years have limited capacity to act, which means that they can, as a rule, only enter into contracts with the assistance of their guardian. Once children have turned 12 years of age, they may independently buy condoms and receive free condoms on request, and they may be provided with other contraceptives if they request this, receive medical advice, and undergo a medical examination to determine whether there are any medical reasons why a specific contraceptive should not be provided. See footnote 4. As from the age of 14 years, minors may witness a will, see footnote 5, and once they have turned 16, they may make a will, see footnote 6. These examples and other rules on minors' capacity are set out in more detail below in this chapter. 6.2 Children's Rights. 6.2.1 Constitution of the Republic of South Africa, 1996. Although minors can invoke the right that the Constitution of the Republic of South Africa, 1996 confers on everyone, they are also afforded special protection by Section 28 of the Constitution. The purpose of Section 28, which is commonly known as the Children's Rights Clause, is to protect children, not their parents. Thus, it affords rights to children, not their parents. See footnote 7. Section 28, subsection 1 of the Constitution gives every child the right 1. To a name and nationality from birth, 2. To family or parental care or appropriate alternative care when removed from the family environment, 3. To basic nutrition, shelter, basic health care, and social services, 5. To be protected from exploitative labor practices, 6. Not to be required or permitted to perform work or provide services that are inappropriate for someone of his or her age, or place his or her well-being, education, physical or mental health, or spiritual, moral, or social development at risk. 7. Not to be detained except as a measure of last resort. If detained, the child has all the rights which Section 12 and 35 of the Constitution afford all detainees. In addition, the child may only be detained for the shortest possible period and has the right to be kept separately from detained adults and to be treated in a manner and kept in conditions that take account for his or her age. 8. To have a legal practitioner assigned to him or her by the state in civil proceedings at state expense if substantial injustice would otherwise result. 9. Not to be used directly in armed conflict and to be protected in times of armed conflict. Section 28, subsection 2 of the Constitution moreover provides that a child's best interests are of paramount importance in every matter concerning the child. Consequently, the best interests of the child must be central in all fields of the law. See footnote 8. 6.2.2 Children's Act 38 of 2005. The rights that a child has in terms of the Children's Act supplement those that the Constitution confers on every child. See footnote 9. The Act, inter alia, amongst other things, seeks to give effect to the child's constitutional rights to family or parental care or appropriate alternative care when removed from the family environment, to social services, to be protected from maltreatment, neglect, abuse, or degradation, and to have paramountcy afforded to his or her best interests in every matter concerning him or her. See footnote 10. The Act also seeks to give effect to the obligations concerning the well-being of children which South Africa has incurred in terms of international instruments such as the African Charter on the Rights and Welfare of the Child and the United Nations Convention on the rights of the child. See footnotes 11. Section 6 of the Act sets out general principles which must guide the implementation of legislation and guide proceedings, actions, and decisions by organs of state relating to a specific child or children in general. See footnote 12. Included among these is the principle that, subject to lawful limitation, all proceedings, actions, or decisions in a matter concerning a child must respect, protect, promote, and fulfill the rights the child has in terms of the Bill of Rights, the best interest of the child standard that is set out in Section 7 of the Children's Act, and the rights and principles that are contained in the Children's Act. See footnote 13. In addition, Section 9 of the Act requires that the standard that the child's best interest is of the paramount importance must be applied in all matters concerning a child's care, protection, and well-being. Other general principles Section 6 sets out are that all proceedings, actions, or decisions in a matter concerning a child must respect the child's dignity, treat him or her fairly and equitably, protect him or her from unfair discrimination on any ground, and recognize his or her need for development and to engage in play and other recreational activities appropriate to his or her age. See footnote 14. If the child is disabled, his or her disability must be recognized and an enabling environment must be created to respond to the child's special needs. See footnote 15. Furthermore, Section 11 lists specific issues which must be considered in respect of children with disabilities or chronic illnesses. Section 6 also provides that, having regard to his or her age, maturity, and stage of development, the child must be informed of any action or decision in a matter which significantly affects him or her. See footnote 16. And, if it is in the child's best interests, his or her family must be given an opportunity to express their views in any matter concerning the child. See footnote 17. In addition, Section 10 affords every child who is of such an age, maturity, and stage of development as to be able to participate in a matter concerning him or her, the right to participate in that matter in an appropriate way. Due consideration must be given to the child's views. Section 6 further requires that an approach which is conducive to conciliation and problem solving must be adopted in any matter that concerns a child, and that a confrontational approach must be avoided. A delay in any action or decision regarding the child must be avoided as far as possible. See footnote 18. Section 12 affords every child the right not to be subjected to social, cultural, and religious practices which are detrimental to his or her well-being. See footnote 19. The section specifically provides that children below the minimum legal age for marriage may not marry or get engaged. See footnote 20. Once they reach the minimum marriageable age, they may not be given out in marriage or engagement without their consent. See footnote 21. The section further prohibits female circumcision and genital mutilation and virginity testing of children below the age of 16 years. See footnote 22. A virginity test may be performed on a child who is over the age of 16 years only if it is done in the manner that is prescribed by the regulations under the Act, and the child has consented in the prescribed manner and has received proper counseling. See footnote 23. A male child who is below the age of 16 years may not be circumcised unless the circumcision is performed for medical reasons on the recommendation of a medical practitioner or for religious purposes in accordance with the practices of the particular religion, for example, the Jewish faith. See footnote 24. Taking into consideration his age, maturity, and stage of development, every male child has the right to refuse circumcision. See footnote 25. If the child has already turned 16, he may be circumcised only if the circumcision is performed in the manner that is prescribed by the regulations, and he has given consent in the prescribed manner and has received proper counseling. See footnote 26. The Customary Initiation Act 2 of 2021 imposes additional duties on traditional leaders, initiation school principals, parents, and various other parties in respect of customary initiation. It also regulates governance and oversight of initiation schools. As cultural matters, which include customary initiation and customary initiation schools, are areas where the provinces and national legislature have concurrent legislative powers. See footnote 27. Some provinces have also enacted legislation on customary initiation and/or initiation schools. See footnote 28. Section 13 entitles every child to access to information on health promotion, the prevention and treatment of ill health and disease, sexuality, reproduction, his or her health status, and the causes and treatment of his or her health status. It also affords the child the right to confidentiality regarding his or her health status and the health status of his or her parent, caregiver, or family member, unless maintaining such confidentiality is not in the child's best interests. See footnote 30. The health information that is provided must be relevant and must be in a format that is accessible to children. In providing the information, due consideration must be given to the needs of children with disabilities. See footnote 31. Even though the Constitution confers a right of access to court on everyone, see footnote 32, and the common law regulates the minor's capacity to litigate, footnote 33, Section 14 of the Children's Act specifically empowers every child to bring a matter to court and to be assisted in bringing a matter to court. The first part of the section, which empowers every child to bring a matter to court, reaffirms the constitutional right of access to court and relates it specifically to children. See footnote 34. This part of the section ensures that every child has access to court either directly, for example, when the minor's guardian institutes litigation on behalf of the minor or assists the minor in litigation, or indirectly, for example, when the court appoints a curator ad litem or legal representative for the minor. See footnote 35. As Section 14 does not prescribe the manner in which the minor must bring a matter to court or the way in which he or she must be assisted in bringing the matter to court, the court must decide these matters by applying the standard of the best interests of the child. See footnote 36. In FB versus MB, see footnote 37, the court held that it would refuse a minor's request to be assisted by his or her own legal representative in terms of Section 14 in exceptional circumstances only, particularly if the minor is a party to legal proceedings. In this case, the minor's parent was prepared to pay for the minor's legal representation. In the absence of a financial benefactor, the minor would only be able to obtain legal representation in terms of Section 28, subsection 1, paragraph H of the Constitution, in which event it would have to be shown that substantial injustice would result if the minor were unrepresented. See footnote 38. Section 15 lists the persons who may approach the court to enforce the rights that are conferred by the Bill of Rights and the Children's Act. They are 1. A child who is affected by or involved in the matter to be adjudicated. 2. Anyone acting in the child's interests or on behalf of another person who cannot act in his or her own name. 3. Anyone acting as a member of or in the interest of a group or class of persons. 4. Anyone acting in the public interest. See footnote 39. Apart from conferring rights on children, the Children's Act provides that every child has responsibilities appropriate to his or her age and ability towards his or her family, community, and the state. See footnote 40. 6.2.3 United Nations Convention on the Rights of the Child and African Charter on the Rights and Welfare of the Child. South Africa ratified the United Nations Convention on the Rights of the Child in 1995 and the African Charter on the Rights and Welfare of the Child in 2000. So just quickly here to define what ratify means according to the sentence. In law, to ratify means to give formal approval or consent to an agreement or action, such as a treaty or a contract, thereby making it legally binding and enforceable. Many of the provisions of the Children's Act embody the obligations South Africa has incurred by ratifying these international instruments. Thus, for example, the provision that every child has responsibilities appropriate to his or her age and ability towards his or her family, community, and the state was included in the Children's Act on the strength of the African Charter on the Rights and Welfare of the Child and the need to Africanize the new Children's Statute. That was in quotes. See footnote 41. Other noteworthy provisions include the stipulation in the Charter that the best interest of the child must be the primary consideration in all actions concerning the child. See footnote 42. And the stipulation in the Convention that the best interests of the child must be a primary consideration in all actions concerning the child. See footnote 43. The Charter further provides that every child must be given an opportunity to express his or her views in all judicial and administrative proceedings which affect him or her, and to have those views taken into consideration in accordance with the provisions of the law. See footnote 44. While the Convention provides that children who are capable of forming their own views must be given the right to express those views freely in all matters that affect them, and those views must be given due weight, taking the child's age and maturity into account. See footnote 45. These provisions are echoed in sections 6, 10, and 31 of the Children's Act. See footnote 46. 6.3 The legal status of an infant. In view of the considerable difference in status between an infant, that is, a child below the age of 7 years, and a minor, that is, a child between the ages of 7 and 18 years, see footnote 47, the legal status of these persons are dealt with separately, that of the infants being covered first. 6.3.1 Capacity to act. An infant has no capacity to act and cannot conclude any juristic act. This is so not because the law denies the existence of an infant's ability to form a will, but rather because the law attaches no consequences to his or her expression of will. See footnote 48. Even if there is in fact agreement between an infant and another party, this is ignored by the law. Anything that is transferred to an infant in terms of an agreement between the infant and a third party can be reclaimed with an enrichment action. See footnote 49. However, an infant's act may constitute a juristic fact, giving rise to legal consequences. For example, if an infant destroys somebody's property, the juristic fact is that the owner's right of ownership to that property ceases, but this still does not change the infant's act into a juristic act. See footnote 50. Please just note here, I will carry on with the pronunciation of infants, as it is the right Latin pronunciation, although feel free to read it as infants, if you will, or infants. It really shouldn't matter. I'm just trying as much as I can to stay true to the original pronunciation. An infant cannot conclude a juristic act even with the assistance of his or her guardian. See footnote 51. The guardian has to act for the infants and on the infant's behalf. See footnote 52. This applies even to a donation. The court, the master of the high court, or the infant's guardian must accept the donation on the infant's behalf. Even if it is the infant's guardian who is the donor, the guardian has to accept the donation on the infant's behalf, and it has to be made clear that the donation is being accepted on the infant's behalf. See footnote 53. Once the guardian has entered into a contract on the infant's behalf, it is on the infant that rights are conferred and duties imposed, and not on the guardian, because the infant has legal capacity and can have rights, duties, and capacities. See footnote 54. Certain juristic acts cannot be performed by the guardian on the infant's behalf at all. For instance, an engagement or a marriage. See footnote 55. A guardian may conclude an insurance contract on the infant's life, but the benefits that may be paid in terms of the insurance policy are limited by statute. See footnote 56. In practice, infantes, so now that would mean many of them, one infants, many infantes, do enter into contracts such as buying toys and sweets. Strictly speaking, all such transactions are void. However, it is unlikely that a court would entertain a case about such a contract, as the maxim de minimis non curat lex, that is, the law is not concerned with trivialities, would be applied. So just to extend on de minimis non curat lex, it basically means that the law does not take action in trifling matters or matters of no value or importance. That's basically what it means. An infant can incur liability on the ground of unjustified enrichment or negotieram gescio because these forms of liability are not based on capacity to act. See footnote 57. And if we can just extend on the meaning of negotierum gestio, it's Latin for management of business in quotes. It is a legal principle where a person, the gesture, voluntarily and without prior consent steps in to manage another person's affairs. So the dominus negoti in Latin, to prevent harm or to protect their interests. It originates from Roman law. It creates a quasi-contract obligating the owner to reimburse the gesture for necessary expenses but not to pay for services. It's an act of generosity rather than profit-making. I hope that makes sense. 6.3.2 Capacity to litigate. In terms of the common law, an infans does not have locus standi in judicio and cannot be a party to a lawsuit even if he or she is assisted by his or her guardian. So we previously came across this term of locus standi in judicio, and just to go back a little bit, in legal terminology, firstly, judicio mostly commonly appears within the Latin phrase locus standi in judicio, the one we are talking about, which refers to a person's legal standing or capacity to participate in court proceedings as a litigant. That's basically what it means. The guardian must always litigate for the infants and on the infants' behalf. See footnote 58. The litigation is brought or defended in the name of the guardian in his or her capacity as guardian. Whether the common law position still applies is not entirely clear. Section 14 of the Children's Act provides that every child, in quotes, has the right to be assisted in bringing a matter to court. It is arguable that the word every, in quotes, amends the common law by conferring limited capacity to litigate on an infant and entitling him or her to assistance which will supplement his or her limited capacity to litigate. It is unlikely that this is what the legislature had in mind, for such an interpretation would have the extraordinary results that an infant would be able to litigate with his or her guardian's assistance, while being unable to enter into even the most basic contract with his or her guardian's assistance, which could surely not be in the best interests of the child. Consequently, it is submitted that Section 14 should not be interpreted as constituting a legislative abolition of the firmly established common law principle that an infant does not have capacity to litigate. See footnote 59. And here, just quickly, the word abolition would mean an action of ending or stopping or scraping a system, practice, or institution. 6.3.3 Capacity to incur delictual and criminal liability. Since an infant is completely unaccountable in law, he or she can never be criminally liable. See footnote 60. Nor can an infant be delictually liable where liability is based on fault. See footnote 61. An infant may, however, be liable for delicts that are not based on fault. Thus, an infant may be sued under the Actio de Pauperi if he or she is the owner of a domestic animal, such as a dog or a goat, that has caused damage, and may incur vicarious liability if his or her employee commits a delicт in the execution of the employee's duties. See footnote 62. If the infant's guardian uses the infant as his or her agent or instrument, or negligently fails to prevent the infant from causing damage, the guardian may be held personally liable for damage the infant causes. See footnote 63. 6.4. The legal status of a minor. 6.4.1. Capacity to act. Minors between the ages of 7 and 18 years have limited capacity to act. The influence this has on a minor's capacity to enter into specific juristic acts is dealt with immediately below. See footnote 64. A. Contracts. Point 1. General. Generally, a minor can incur contractual liability only if he or she is assisted by his or her guardian when the contract is concluded. See footnote 65. A minor may, however, enter into an unassisted contract if the contract improves his or her position without imposing duties on him or her. See footnote 66. In other words, the guardian's consent is unnecessary if the minor enters into a contract in terms of which the other party incurs duties while the minor acquires rights only. Thus, for example, a minor may accept a donation without assistance or enter into an agreement that releases him or her from a debt as long as the agreement does not impose any obligation on him or her. See footnote 67. If a minor enters into an unassisted contract which imposes duties on him or her, he or she is not contractually liable. See footnote 68. On the minor's side, the contract creates a natural obligation, naturalis obligatio, which is unenforceable against him or her and his or her guardian. See footnote 69. Thus, it might be stated that the contract is void when viewed from the perspective of the minor. It must be emphasized, however, that the contract is not fully void, see footnote 70, because it imposes a civil obligation, civilis obligatio, on the other party to the contract, see footnote 71, which is enforceable against that party. See footnote 72. One can therefore say that a minor's unassisted contract is partially valid, inchoate or limping, in the sense of being enforceable at the option of the minor or his or her guardian. Stating that the contract is enforceable at the option of the minor does not mean that the contract is voidable, because a voidable contract is valid until set aside, while a minor's unassisted contract does not bind the minor at all and, in that sense, is not valid as against the minor. See footnote 73. It is unclear whether this is also the position if the unassisted contract falls within the ambit of the Consumer Protection Act 68 of 2008. And just quickly again, ambit refers to the scope, the extent, or the bounds of something. See footnote 74. Section 39, subsection 1, paragraph B of the Act provides that an agreement to enter into a transaction for the supply of goods or services to an unemancipated minor consumer and an agreement to supply goods or services to such a consumer, see footnote 75, is voidable at the option of the consumer, in quotes, unless it is ratified by the minor's guardian or by the minor after he or she is emancipated or becomes an adult. See footnote 76. In view of the uncertainty as to the correct description of the nature of a minor's unassisted contract and the frequent inaccurate use of the term void and voidable in quotes to describe such contracts, it is submitted that in employing the term voidable in quotes, the legislature did not intend to deviate from the common law position regarding a minor's unassisted contract and to dictate that such contracts are valid until set aside by the minor. It simply used the term loosely. See footnote 77. In terms of the common law, it is the guardian or the minor with the assistance of his or her guardian or the minor upon reaching majority who decides whether an unassisted contract should be repudiated or honored. So just quickly, repudiate in law means to refuse to perform your obligation under a contract or to declare a contract no longer valid. That's what it means. See footnote 78. It is unclear whether this rule applies to agreements which fall within the scope of the Consumer Protection Act, because Section 39, subsection 1, paragraph B of the Act provides that a minor's unassisted contract is voidable at the option of the consumer, in quotes. It is arguable that the legislature sought to indicate that the minor may independently, that is, without the assistance of his or her guardian, decide whether the agreement should be repudiated or honored. However, it could also be argued that the guardian's assistance is still required because the wording of the section does not expressly amend the common law. See footnote 79. I favor the latter view on the ground of the presumption that a statute does not alter the existing law to a greater degree than is necessary. To my mind, there is no constitutional or other need that dictates that Section 39, subsection 1, paragraph B should be found to have removed the requirement of the guardian's assistance. Once the guardian or the minor with the assistance of his or her guardian has decided whether the contract should be repudiated or honored, the other party to the contract has no option but to abide by this decision. In other words, the other party cannot rely on the minor's minority to avoid his or her own contractual obligation. Nor can the other party avoid his or her contractual obligation by invoking the exceptio non adimpleti contractus. This exceptio entails that one party to a contract that provides for reciprocal performance cannot claim the other party's performance without also performing or tendering performance. As the exceptio is founded on the principle of reciprocity, it cannot be invoked against someone whose performance is not yet due or someone who is not contractually bound to perform at all, as is this the position in the case of an unassisted minor. Thus, it does not offer an avenue for withholding performance to someone who has entered into a contract with an unassisted minor. Nor does it enable that person to hold the minor in terms of the contract. See footnote 80. What normally happens is that the minor raises he or her minority as a defense when sued on the contract. However, nothing precludes the minor from taking the initiative and applying for an order declaring that he or she is not contractually liable. See footnote 81. The minor cannot sue the other party for performance in terms of the contract while withholding his or her own performance, because the minor would need his or her guardian's consent for the litigation. See footnote 82. And if the guardian consents to the litigation, the guardian will obviously be ratifying the minor's contract. See footnote 83. If a minor has performed in terms of an unassisted contract and the contract is repudiated, the minor may recover whatever he or she has performed. See footnote 84. Property other than money is recovered by the re vindicatio and money by a condictio. See footnote 85. The value of the minor's performance is reduced by the amount by which the minor was unjustifiably enriched by the other party's performance. See footnote 86. Because a minor's unassisted contract cannot be enforced against the minor does not have to apply for restitutio in integram, that is, return to the previous position, in order to recover his or her performance. See footnote 87. Restitutio in integram applies if the minor, with the required assistance, entered into a contract which was to his or her detriment when it was made, and he or she has performed in terms of that contract. See footnote 88. The minor's natural obligation may serve as the object of suretyship. See footnote 89, and it can be novated and ceded. See both 90 and 91. And just quickly here to define novated and ceded. Novated would mean it would be replaced with a new contract, and ceded would mean it would be surrendered or formally transferred to another party by agreement. Point 2. Assistance by the guardian. General. The objective of the rule that a minor cannot incur contractual liability without his or her guardian's assistance is to protect the minor against his or her own immaturity of judgment. See footnote 92. This consideration falls away if the minor acts with the guardian's assistance. Then the minor is liable ex contractu as if he or she were a major. See footnote 93. And just quickly here to define ex contractu. In law, ex contractu is a Latin term meaning from a contract, and it refers to a legal liability. If the minor has more than one guardian, the consent of one of them is usually sufficient. However, in some instances, such as the alienation and encumbrance of the minor's immovable property, the consent of all the guardians of the minor is required. See footnote 94. The guardian's assistance may take various forms. In the first place, the guardian may act on the minor's behalf. See footnote 95. Alternatively, the minor may personally enter into the contract with his or her guardian's consent. See footnote 96, or the guardian may ratify the agreement after it has been concluded. See footnote 97. The guardian's consent may be given expressly or tacitly. See footnote 98. And it may relate to a single transaction or to several. So let's just read here quickly. In law, tacitly means understood or implied without being directly expressed. It's like an unspoken agreement or action that carries a weight of consent or approval. For example, if parents allow their child to conduct his or her own business, the minor may enter into all transactions relating to that business. See footnote 99. Whether or not a minor in fact has the required consent depends on the circumstances of each particular case. As Caney, see footnote 100, puts it, to give his assistance, the guardian must bring his mind deliberately to bear upon the subject. His mere assent without consideration, especially if it be subsequent, is valueless, nor is knowledge by him of the fact of a contract without information of its terms to be construed as assistance by him. So just quickly here, the word assent would mean the expression of approval or agreement. It can be used as both a noun and a verb. The guardian need not have knowledge of each and every term of the contract, but must be aware of its nature and essential terms. See footnote 101. Consent obtained through fraud or undue influence is worthless. Note 102. A guardian who has consented to a transaction may withdraw consent prior to the conclusion of the transaction. See footnote 103. The guardian is obliged to assist the minor in entering into legal transactions which are beneficial to the minor, or to conclude such transactions on the minor's behalf. If the guardian is unable or unwilling to do this, the court may order the guardian to do so or itself give the required consent. See 104. The court would also intervene if the guardian's own interests in a transaction clash with his or her duty to further the minor's interests, or where the guardian's consent is insufficient in itself. For example, in respect of alienating or mortgaging a minor's immovable property. See both 105 and 106. There are some contracts the guardian cannot conclude on the minor's behalf, although the guardian may consent to the minor's entering in such contracts. This is the case in respect of an agreement of a closely personal nature, such as an antenuptial contract. See footnote 107. And a contract that will come into operation only after the minor has attained majority. See footnote 108. It is submitted that a guardian may not conclude an employment contract that contravenes Section 43 of the Basic Conditions of Employment Act 75 of 1997 on behalf of the minor, or consent to the minor's entering into such a contract. Section 43, subsection 1, provides that a minor who is below the age of 15 years or below the minimum legal school leaving age may not be required or permitted to work. Section 43, subsection 3, provides that a person who requires or permits such a minor to work commits an offense. Although a contract that is concluded in contravention of a statutory prohibition is not necessarily void. See footnote 109. It is submitted that a contract that contravenes Section 43 ought to be illegal and void. See footnote 110. South Africa has ratified various international instruments which combat child labor and require the setting of a minimum age for entry into employment. These instruments include the United Nations Convention on the Rights of the Child and African Charter on the Rights and Welfare of the Child, and Convention 138 of the International Labour Organization of 1973. See footnote 111. The Convention on the Rights of the Child and the African Charter on the Rights and Welfare of the Child further require states parties to provide for appropriate penalties or other sanctions to ensure effective enforcement of, inter alia, the ban on the employment of children below the minimum employable age. Section 43 complies with the requirement regarding the minimum employable age these international instruments set. Enforcement of the minimum employable age would be more effective if no recognition at all were afforded to a contract that contravenes Section 43. Nullity of the contract, linked with the imposition of the criminal sanctions on the employer, would be a more appropriate penalty and sanction and would send a stronger message of discouragement of child labor than would the mere imposition of a criminal sanction on the offending employer. See footnote 112. A guardian may conclude an insurance contract on the minor's life or assist the minor in entering into such a contract. The benefits that may be paid in terms of the insurance policy are, however, limited by statute if the minor is below the age of 14 years. See footnote 113. Liability of the guardian. As a rule, the guardian does not incur personal liability in respect of the minor's contract, regardless of whether the guardian assists the minor or acts on the minor's behalf. See footnote 114. The other party can therefore not claim performance of the minor's obligations from the guardian. See footnote 115. The guardian is, however, liable on the contract if the minor acted as his or her agent. See footnote 116. A guardian is also liable if he or she guaranteed the minor's performance or bound himself or herself as surety for the minor's performance. See footnote 117. In this situation, the guardian's liability arises only if the minor does not perform in terms of the contract. A guardian may also incur liability on the basis of negotiorum gestio if he or she is the child's parent. Parents have a duty to support their children. See footnote 118. If a third party fulfills the duty of support on behalf of a parent by supplying his or her child with necessaries like food and clothing, the parent may be liable on the basis of negotiorum gestio. In this case, the guardian's liability does not arise contractually but quasi-contractually. See footnote 119. Point 3. Ratification. As a minor's unassisted contract creates a natural obligation, it can be ratified by the guardian or by the minor once he or she has attained majority. Ratification converts the minor's natural obligation into a civil one, with the result that the contract becomes fully enforceable as against both parties with retroactive effect. See footnote 120. However, a guardian cannot ratify a contract he or she could not validly have concluded on the minor's behalf at the time when the contract was made. See footnote 121. Ratification may take place either expressly or tacitly. See footnote 122. Express ratification presents no problem, but it can be quite difficult to determine whether a contract has been tacitly ratified, especially if ratification by a minor who has attained majority is at issue. The court considers the former minor's conduct and deduces from all the circumstances whether or not he or she had the intention of ratifying the contract. See footnote 123. It is unclear whether a former minor who is unaware of his or her rights can ratify a contract after attaining majority. The former minor may, for example, not know what he or she is not contractually liable and is entitled to repudiate the contract. Would an act that would normally amount to ratification be ratification in such circumstances? On the other hand, one can rely upon the maxim ignorantia juris haud excusat, that is, ignorance of the law is no excuse. According to this view, the former minor's ratification is assumed and the minor is contractually liable. See footnote 124. On the other hand, because of the decision of the Appellate Division, now the Supreme Court of Appeal, in S versus De Blom, see footnote 125, the ignorantia juris haud excusat no longer applies without qualification. It seems that an interference of ratification can be rebutted if the former minor's ignorance is reasonable and excusable. See footnote 126. In Edelstein versus Edelstein, see footnote 127, it was held that an antenuptial contract that was concluded without the necessary consent cannot be ratified by the minor or the minor's guardian once the marriage has taken place, because ratification would amount to an impermissible change of the matrimonial property system. See footnote 128. This is still the position if the minor enters into a civil or customary marriage with consent but concludes an antenuptial contract without consent. In terms of the Civil Union Act 17 of 2006, only persons who have already reached the age of 18 years may enter into a civil union. See footnote 129. Thus, a minor cannot validly enter into a civil union regardless of whose consent he or she obtains. However, he or she might conclude an unassisted internuptial contract in anticipation of a civil union he or she intends entering into upon attaining majority. In such event, the antenuptial contract could be ratified prior to the coming into existence of the civil union. Once the civil union has taken place, the decision in Edelstein versus Edelstein, see footnote 130, would apply, and ratification would be impermissible. See footnote 131. The position would be the same if a minor concluded an unassisted antenuptial contract in anticipation of a civil or customary marriage he or she intended entering into upon attaining majority. Point 4. Statutory exceptions regarding a minor's capacity to incur contractual liability. Some acts create exceptions to the rule that a minor cannot incur contractual liability without his or her guardian's assistance. For example, number 1, unless the article of the particular mutual bank, otherwise, a minor over the age of 16 years may be a member of or a depositor with any mutual bank. He or she may, without the consent or assistance of his or her guardian, execute all necessary documents, give all necessary acquaintances, and cede, pledge, borrow against, and generally deal with his or her share or deposit as he or she thinks fit. See footnote 132. Number 2, unless the memorandum of association or articles of association of a bank provide otherwise, a minor over the age of 16 years may be a depositor with a bank. He or she may, without the consent or assistance of his or her guardian, execute all necessary documents, give all necessary acquaintances, and cede, pledge, borrow against, and generally deal with his or her deposit as he or she thinks fit. See footnote 133. Number 3, if the rules of a registered friendly society permits this, any minor may be a member of the friendly society. Once the minor has turned 16, he or she may execute all necessary documents and give all necessary acquaintances without the consent of his or her guardian. See footnote 134. Point 5. Misrepresentation by the minor. It is generally agreed that a minor who misrepresents himself or herself to be a major, to be emancipated, or to have the necessary consent, and who thereby misleads somebody to enter into a contract with him or her, ought to be liable. But there is no unanimity on the basis of such liability. See footnote 135. The two possible grounds on which the minor could be held liable are the contract he or she entered into and the delict he or she committed, namely the misrepresentation. Each of these bases is considered below. Contractual liability. Those who advocate contractual liability for a minor who committed a misrepresentation advance various reasons for their theory. In the first place, they point out that the Roman Dutch writers expressly denied the remedy of restitutio in integrum to a minor who committed a misrepresentation. See footnote 136 and 137. Restitutio in integrum, it is argued, presupposes a binding contract and, as the old writers deal with and deny the remedy to the fraudulent minor, it is implied that there is a binding underlying contract. See footnote 138. This argument is unconvincing because restitutio in integrum has been relied upon in circumstances where it was unnecessary to do so. Restitutio in integrum should only be used in respect of a minor's binding contract. That is, in respect of a contract the minor concluded with the necessary assistance or a contract the minor's guardian concluded on the minor's behalf. See footnote 139. So just quickly to interject on the paragraph here, restitutio in integrum is a Latin legal term meaning restoration to the original condition or restoration to a pre-existing position. So it refers to the principle or remedy of placing a party back into the situation they would have been in if a wrongful act or event had not taken place. However, Roman Dutch practice was also to apply for restitutio in integrum in cases where a minor had entered into an unassisted contract. See footnote 140. In these circumstances, the minor was in fact not contractually liable and therefore did not have to rely on restitutio in integram. The minor could instead simply have used the re vindicatio or a condictio to cover the performance he or she had rendered in terms of the unenforceable contract. Invocation of restitutio in integram in circumstances where it was unnecessary to rely on the remedy surely does not justify the inference that the minor is contractually liable purely because of his or her misrepresentation. As Cockrell, read footnote 141, puts it, the unassisted minor's contract does not require setting aside by restitutio in integram. It is simply not binding on the minor as a matter of law. How then can minors be punished for fraud by denying them a remedy that is not needed in any event? So just quickly to go back here to define re vindicatio. This is a legal remedy in South African law that allows an owner to reclaim property from an unlawful possessor, regardless of whether the possessor acted in good or bad faith. So this is rooted in Roman Dutch law. It functions as a property right-based action where the owner asserts their right to possession against someone else who is physically in control of it. In this context, the decision in Lowe versus MJ and H Trust Pty Ltd, see footnote 142, should be mentioned. Judge Eloff held that because the minor had misrepresented himself as emancipated when he bought a motorcycle from a major without the necessary assistance, he could not recover the part of the purchase price he had already paid. Judge Eloff further held that the fact that a fraudulent minor is denied restitutio in integram does not mean that he is contractually bound because of his misrepresentation. Judge Eloff argued that because the minor is not contractually bound, he cannot be ordered to pay the balance of the purchase price. The minor's misrepresentation, therefore, does not result in the contract being enforced against him. It merely results in the minor not being allowed to claim restitutio in integram, and because the minor cannot claim restitutio in integram, he cannot recover the contractual payments he made. It is submitted that this decision is wrong. See footnote 143. It is indeed correct to say that refusing the minor restitutio in integram does not mean that the minor becomes contractually liable. Once it is agreed that a minor who enters into an unassisted contract cannot be contractually liable, it is clear that the remedy of restitutio in integram is not required at all. As indicated above, if a contract is not enforceable against someone, he or she can simply recover his or her performance with the re vindicatio or condictio. Thus, the court erred in holding that denying the minor restitutio in integram barred him from recovering the part of the purchase price he had already paid. The result of Judge Eloff's decision is that the minor was both held bound because he was not allowed to recover the payments he made and not bound because he was not compelled to pay the balance of the purchase price. This is untenable. And just quickly to jump in here with the definition, in a legal context, untenable means a position, claim, or condition that cannot be defended, maintained, or supported by law, reason, or evidence. Either the minor is contractually liable, in which case he cannot recover what he has performed and is bound to carry out his remaining obligations, or he is not contractually liable, in which case he may recover what he has performed and is not bound to render further performance. In Low's case, the minor's claim for recovery of payments already made should therefore have been upheld, and the major's counterclaim for full payment of the outstanding amount should have been dismissed. See Note 144. This would not have left the major without a remedy, for he or she could still have sued the minor in delict or for unjustified enrichment. See footnote 145. In the second place, those who advocate contractual liability of a minor who commits misrepresentation rely on estoppel. See footnote 146. They argue that if someone enters into a contract with a minor on the strength of the minor's misrepresentation, the minor cannot raise his or her minority as a defense. Consequently, the minor is held liable as if he or she were in fact a major when the contract was concluded. The other party can therefore simply sue the minor on the contract and then, by means of estoppel, frustrate any reliance by the minor on his or her minority. This argument should be rejected on policy grounds, invoking estoppel to hold the minor to the false impression he or she created and enforcing the contract against him or her has the undesirable consequence of permitting the minor to alter his or her capacity to act by committing a misrepresentation, even though his or her fraudulent conduct or omission does not inevitably mean that he or she has the necessary ability to judge that he or she therefore does not need the legal protection that is ordinarily afforded to minors. See footnote 147. And here just quickly, in law, to define estoppel, estoppel is a principle that prevents a person from asserting a claim or right that contradicts a previous statement, action, or established fact. It is arguable that Section 39, subsection 2 of the Consumer Protection Act is authority for the view that a fraudulent minor is contractually liable insofar as agreements in terms of the acts are concerned. See footnote 148. In terms of Section 39, subsection 1, paragraph B of the Act, an agreement to enter into a transaction for the supply of goods or services to an unemancipated minor consumer and an agreement for the supply of goods or services to such a consumer are voidable at the option of the consumer unless the consumer has the consent of his or her guardian to enter into the agreement or the agreement is ratified. See footnote 149. Section 39, subsection 2 creates an exception to this rule. It provides that the rule in Section 39, subsection 1, paragraph B does not apply if the minor or somebody acting on the minor's behalf induced the supplier to believe that the minor had unfettered capacity to enter into the contract, or if the minor or a person acting on his or her behalf tried to obscure or suppress the fact that the minor did not have unfettered capacity to enter into the contract. The word unfettered means uninhibited or unrestricted. Although this section does not expressly rate that a fraudulent minor is contractually liable, the implication of the inapplicability of the rule in Section 39, subsection 1, paragraph B, might be that the contract is not voidable at the option of the minor. See footnote 150. Accepting this argument would lead to the same policy concern that applies in respect of invoking estoppel to hold a fraudulent minor to the false impression he or she created and enforcing the contract against him or her, namely, that it is undesirable to permit the minor to alter his or her capacity to act by committing a misrepresentation. Delictual liability. It is submitted that delict ought to be the basis on which the fraudulent minor is held liable. See footnote 151. By making delict the basis of liability, the past judgments in which the minor was held liable for the contract price are not explained. See footnote 152. In those judgments, there was no discussion of the ground on which the minor was held liable. Consequently, it is doubtful whether they can serve as authority to substantiate the basis of the minor's liability as being contractual in nature. If a minor openly claims to be a major, to have the necessary assistance, or to be emancipated, there is no doubt that he or she is committing a misrepresentation. See footnote 153. The other party does not have to inquire into the truth of the minor's statement unless he or she has good cause for believing that he or she is in fact dealing with a minor. See footnote 154. In case of a tacit misrepresentation, the issue is whether the minor's conduct amounts to a misrepresentation. This depends on the circumstances of each case. If the minor knows that the other party thinks he or she is a major, is emancipated, or has the necessary consent and does nothing to remove this erroneous belief, the minor commits a misrepresentation. See footnote 155. In the case of an erroneous belief that the minor is a major, the minor must be old enough to be reasonably mistaken for a major. See footnote 156. However, if the other party is the minor's blood relation, it is accepted that he or she knew that the minor was in fact a minor. See footnote 157. Once it has been established that the minor committed a misrepresentation, the onus rests on the minor to prove that the other party was not misled. The misrepresentation must have been the cause that induced the other party to enter into the contract with the minor. See footnote 158. Obviously, the other party must have suffered loss. Point 6. Unjustified enrichment. In terms of Roman and Roman Dutch law, a minor incurred liability if he or she entered into an unassisted contract and benefited from the contract. The benefit theory was adopted in our law in Nell versus Divine, Hall and Company, see footnote 159, in which it was held that if a contract taken as a whole was to the minor's benefit, the minor was bound by it. See footnote 160. This view, although incorrect, was applied fairly consistently by our courts until it was authoritatively rejected by the Appellate Division in Edelstein versus Edelstein. See footnote 161 and 162. In Edelstein, it was correctly held that a minor is not contractually liable whenever a contract is in a vague and general way, in quotes, to his or her advantage, but that the minor may be held liable ex lege on the ground of unjustified enrichment. See footnote 163 and 164. Ex lege is a Latin adverb that means by law, or by virtue of law, or as a matter of law. So it just describes something that occurs or is derived directly from legal principles or statuses, rather than through a specific contract agreement or demand. Liability on the ground of unjustified enrichment arises if one person obtains a patrimonial advantage, that is enriched, at the expense of another in the absence of a legal ground justifying the enrichment. See footnote 155. The enrichment claim is limited to the lesser of either the amount by which the enriched person's estate remains enriched at the date of institution of the action, that is, the date of service of the summons, or the amount by which the other person's estate remains impoverished at the date. See footnote 166. In arriving at this amount, the contract price is ignored. It is the actual value of the asset at the time of institution of the action that is the issue. See footnote 167. Accordingly, if the value of the asset has decreased by the time the action is instituted, it is the decreased value that is used. If the asset was lost prior to the institution of the action, the impoverished party cannot claim anything. If the asset was alienated, the impoverished party can claim only what is left of the proceeds unless the enriched party used the proceeds to obtain the necessaries such as food, clothing, accommodation, and medical treatment. See footnote 168. In the latter case, the cost of the necessaries is the value that is used to determine the amount of the enrichment, even if nothing remains of those necessaries. The reason for this rule is that the enriched party would have had to pay for the necessaries out of his or her own pocket, were it not for the fact that he or she had the asset or its proceeds. Therefore, the extent of his or her enrichment is equal to the cost of the necessaries. See footnote 169. The difference between contractual liability and liability on the ground of unjustified enrichment can involve a great deal of money. Contractual liability entails that the minor is liable for the contract price, irrespective of when the action is instituted. In contrast, if the minor is liable on the ground of unjustified enrichment, he or she is only liable for the value of the asset at the time when the action is instituted. The amount for which the minor may be liable on the ground of unjustified enrichment may therefore be much less than the contract price. Point 7. Restitutio in integram. If a minor entered into a contract with his or her guardian's consent, or if the guardian validly entered into a contract on the minor's behalf, the minor may still escape contractual liability by relying on restitutio in integram. See note 170. Restitutio in integram is available even if the court consented to the minor's contract, because the court might have erred or might have been misled. Read footnote 171. Restitutio in integram is an extraordinary remedy and is only available if the contract was prejudicial to the minor when it was concluded. See footnote 172. Prejudice arising at some later stage is irrelevant. See footnote 173. The purpose of restitutio in integram is to restore the status quo ante, that is, the previous position. This means that complete restitution from both sides must take place, placing both parties in the position they would have been in had they never entered into the contract. Each party must return everything he or she received under the contract, as well as the proceeds or any advantage derived from the contract. Each party must also compensate the other for any loss suffered as a result of the contract. See footnote 174. As indicated above in this chapter, restitutio in integram is only necessary if the minor is indeed contractually liable. Therefore, if the minor did not have the requisite assistance when he or she entered into the contract, he or she is not contractually liable and need not seek restitutio in integram. See footnote 175. If some doubt exists as to whether or not the minor is contractually liable, the minor could apply for restitutio in integram, but then the minor would have to prove that the contract was to his or her detriment when it was concluded. See footnote 176. Restitutio in integram is available not only in respect of contracts. The minor may invoke the remedy whenever he or she has suffered prejudice. See footnote 177. For example, in Landers versus Estate Landers, see footnote 178, restitutio in integram was granted to a minor who had lost his inheritance through his guardian's failure to protect his interests. Restitutio in integram can, however, not be invoked to set aside a marriage or escape delictual or criminal liability. See footnote 179. A minor who misrepresented himself or herself as a major or an emancipated minor or as having the requisite consent to enter into the contract and thereby persuaded the other party to enter into a contract with him or her may not rely on restitutio in integram. See footnote 180. Whether an emancipated minor may obtain restitutio in integram is controversial. It is submitted that restitutio in integram should indeed be available to an emancipated minor, because it is illogical to deny the minor the remedy simply because he or her guardian consented to his or her entering into all transactions within a particular sphere instead of just consenting to one particular transaction. See footnote 181. Restitutio in integram not only affords a cause of action, but may also be raised as a defense. For example, if a minor is sued for performance in terms of a prejudicial contract. See footnote 182. With the assistance of his or her guardian, the minor may apply for restitutio in integram before attaining majority, or the guardian may apply on the minor's behalf. If the guardian fails to assist the minor, a curator ad litem may be appointed to assist the minor in the litigation. See footnote 183. Alternatively, the minor may await majority and then institute the action on his or her own. But in this event, he or she has to consider the possibility of prescription of the claim. Prescription usually takes place 3 years after the date on which the cause of action arises, but in the case of a minor, it is delayed until at least a year after the minor becomes a major. See footnote 184. If after attaining majority, the minor ratifies the contract, he or she is barred from obtaining restitutio in integrum. See footnote 185. Restitutio in integrum accorded to a minor differs from other cases of restitution in that it does not release someone who has bound himself or herself as a surety for the minor. See footnote 186. Thus, if a minor's guardian has stood surety for the minor's obligation, the guardian would still have to meet those obligations. B. Other agreements. The principle that a minor may improve his or her position but not encumber it without the consent of his or her guardian also applies to other agreements. Thus, for example, a real agreement by which a right is transferred to a minor is valid even if the minor is unassisted, but a real agreement by which a minor attempts to transfer a real right to another person without his or her guardian's assistance is invalid. See footnote 187. Likewise, a minor can enter into an unassisted agreement which extinguishes a debt he or she owes, but a minor cannot enter into an unassisted agreement by which another person's debt to him or her is extinguished. See footnote 188. Therefore, someone who entered into a contract with a minor cannot validly render performance in terms of the contract unless the minor is assisted by his or her guardian. If the other party to the contract does render performance, that party is not released from his or her duty to perform, but if the minor is enriched by the performance, the minor may incur liability on the ground of unjustified enrichment. See footnote 189. If the minor performs without his or her guardian's assistance, the performance is invalid and can be recovered. The reason for this rule is that although performance entails an advantage for the minor insofar as his or her indebtedness is terminated, it also entails a disadvantage because the minor loses his or her right of ownership to whatever his or her performance consists of. It must, however, be borne in mind that if a minor entered into a contract with the requisite assistance but rendered performance under that contract without assistance, the minor may not recover his or her performance, for in this case, the minor's guardian is taken to have consented not only to the contract but also to the minor's fulfilling the contract by rendering performance. See footnote 191. C. Wills. Once a minor reaches the age of 14 years, he or she may witness a will. See 192. A person who is 16 years or older may take his or her own will and in it dispose of his or her property as he or she pleases. See 193. D. Marriages and civil unions. Point 1. Civil marriages. A minor may enter into a civil marriage if he or she has the requisite consent. See 194. All the guardians of the minor must consent to the marriage unless the court orders otherwise. See 193. If a guardian is absent, mentally ill, or in any other way incompetent to consent, or if the minor can for any other good reason not obtain the guardian's consent, the presiding officer of the children's court may grant consent. See 196. If a guardian or the presiding officer withholds consent, the minor may approach the High Court for consent. See 197. If the consent of the guardian or guardians or the presiding officer is not obtained and the court does not authorize the marriage is voidable. It may set aside on the application of either 1. The minor's parents or guardian before the minor attains majority and within 6 weeks from the date on which they become aware of the existence of the marriage, or 2. The minor before he or she attains majority or within 3 months thereafter. See footnote 198. If the marriage is dissolved due to lack of consent, the court may take any order with regard to the division of the matrimonial property it deems just. See 199. If the marriage is not dissolved, the patrimonial consequences are the same as if the minor were of age when the marriage was entered into, and any antenuptial contract in terms of which the accrual system is included is deemed to be valid. See footnotes 200 and 201. All female minors below the age of 15 years and all male minors must obtain the consent of the Minister of Home Affairs in addition to obtain their guardian or guardian's consent to the marriage, unless the court authorizes the marriage. See 2.2. Because children below the age of puberty cannot enter into a civil marriage at all, the minister's power to grant consent applies only to marriages of females between the ages of 12 and 15 years and males between the ages of 14 and 18 years. See 203. The age of puberty is 14 years for boys and 12 years for girls. If ministerial consent is not obtained, the marriage is void. The minister may, however, subsequently declare the marriage valid if the marriage is desirable and in the parties' interests and in all other respects complies with the Marriage Act 25 of 1961. See 204. A minor who has previously entered into a valid civil or customary marriage and whose marriage has been dissolved by death or divorce may enter into another civil marriage without consent because he or she attained majority upon entering into the first marriage and the dissolution of the marriage did not revive his or her minority. See footnote 205 and 206. Point 2. Customary marriages. A minor who wants to enter into a customary marriage needs the consent of all his or her guardians, unless the court orders otherwise. See 207. If a guardian is absent, mentally ill, or in any other way incompetent to consent, or if the minor can for any other good reason not obtain the guardian's consent, the presiding officer of the children's court may grant consent. See footnote 208. If a guardian or the presiding officer withholds consent, the minor may approach the High Court for consent. Read footnote 209. If a minor fails to obtain consent from his or her guardian or guardians or the presiding officer and the court does not authorize the marriage is voidable. It may be set aside on the application of either 1. The minor's parents or guardian before the minor attains majority and within 6 weeks from the date on which they become aware of the existence of the marriage, or 2. The minor before he or she attains majority or within 3 months thereafter. See footnote 210. If the marriage is dissolved due to lack of consent, the court may take any order with regard to the division of the matrimonial property it deems just. See 211. It is unclear what the patrimonial consequences are if an unassisted minor's customary marriage is not set aside. See 212. Unless the court authorizes the marriage, every minor who wants to enter into a customary marriage must also obtain the written consent of the Minister of Home Affairs. See Note 213. Ministerial consent does not release the minor from the need to comply with all the other requirements for a valid customary marriage, such as obtaining the consent of his or her guardians. See 214. If ministerial consent is not obtained, the minister may subsequently declare the marriage valid if the marriage is desirable and in the parties' interest and in all other respects complies with the Recognition of Customary Marriages Act 120 of 1998. C. 215. If such declaration is not obtained, the marriage is void. See footnote 216. Point 3. Civil unions. As the Civil Union Act restricts civil unions to persons who have already reached the age of 18 years, a minor cannot enter into a civil union even if he or she is assisted by his or her guardian. See 217. E. Medical treatment, operations, HIV tests, and contraceptives. See footnote 218. A minor who is below the age of 12 years may not have medical treatment without his or her guardian's consent. See 219. The same applies to an operation on a minor who is below the age of 12. The guardian's consent to medical treatment is also needed if the minor has already turned 12 but is immature and does not have the mental capacity to understand the benefits, risks, and social implications of the treatments. See 220. If a minor who has already turned 12 is sufficiently mature and has the mental capacity to understand the benefits, risks, and social and other implications of the medical treatment, the consent of his or her guardian is not needed. See 221. A minor who has already turned 12 may also consent to an operation if he or she is sufficiently mature and has the mental capacity to understand the benefits, risks, social and other implications of the operation. But in such event, he or she must still be duly assisted, in quotes, by his or her guardian. See 222. In the case of an operation, a minor over the age of 12 can therefore not independently give consent unless the operation in issue is a termination of pregnancy. See 223. A minor's guardian may not refuse to assist the minor in respect of an operation or withhold consent to medical treatment or an operation on the ground of religious or other beliefs, unless the guardian can show that there is a medically accepted alternative to the operation or medical treatment. C224. If the minor or his or her guardian unreasonably withholds consent, the Minister of Social Development may give consent. C225. The same applies if the guardian unreasonably refuses to assist a minor over the age of 12 in respect of an operation. C226. The minister may also give consent if the guardian is incapable of consenting, is incapable of assisting the minor, cannot readily be traced, or is deceased. C227. If the minister, the minor, or the guardian refuses or is unable to give consent, the High Court or the Children's Court may give consent. C228. If the treatment or operation is necessary to preserve the minor's life or to save him or her from serious or lasting physical injury or disability, and the need for the treatment or operation is so urgent that it cannot be postponed to obtain the requisite consent, the superintendent, or, in the absence of the superintendent, the person who is in charge of the hospital may consent to it. C229. A minor may undergo an HIV test only if 1. The test is necessary to establish whether a health worker may have contracted HIV due to contact in the course of a medical procedure with any substance from the minor's body that may transmit HIV. 2. Any other person may have contracted HIV due to the contact with a substance from the minor's body that may transmit HIV, and a court has authorized the test. Or 3. The test is in the child's best interests and the necessary consent has been given for the test. C230. If the minor has turned 12 or is below 12 years of age but is sufficiently mature to understand the benefits, risks, and social implication of the test, he or she may independently consent to the test. C231. If the minor is below 12 years of age and is not sufficiently mature to understand the benefits, risks, and social implications of the test, the consent of his or her parent or caregiver, the provincial head of social development, or the designated child protection organization that is arranging the minor's placement is required. C232. If the minor has no parent or caregiver and no designated child protection organization is arranging his or her placement, the superintendent or person in charge of a hospital may consent to the test. C233. If the minor or his or her parent or caregiver is incapable of giving consent, or if the minor, parent, caregiver, provincial head, or child protection organization unreasonably withholds consent, the Children's Court may give consent. C234. If the minor is sufficiently mature to understand the benefits, risks, and social implications of the test may not be performed until the minor has been properly counseled by an appropriately trained person. If the minor is sufficiently mature to understand the implications of the test results, an appropriately trained person must also provide the minor with post-test counseling. C235. If the minor's parent or caregiver knows about the test, he or she must also receive pre- and post-test counseling. C236. If the test results show that the minor is HIV positive, this fact may not be disclosed unless the minor gives his or her consent, if she or he has turned 12 or is below 12 years of age, but is sufficiently mature to understand the benefits, risks, and social implications of the disclosure. See 237. If the minor is below 12 years of age and is not sufficiently mature to understand the benefits, risks, and social implications of the disclosure, the consent of his or her parent or caregiver or the designated child protection organization that is arranging his or her placement must be obtained. See 238. If the minor is below 12 years of age, is not sufficiently mature to understand the benefits, risks, and social implications, and has no parent or caregiver and no designated child protection organization is arranging his or her placement, the superintendent or person in charge of a hospital may consent to the disclosure. See 239. If the minor or his or her parent or caregiver is incapable of giving consent, or if the minor, parent, caregiver, or designated child protection organization unreasonably withholds consent and disclosure is in the child's best interest, the Children's Court may consent to the disclosure. See 240. The Act permits disclosure of the minor's HIV positive status without consent only if the 1. person who makes the disclosure does so within the scope of his or her powers and duties in terms of the Children's Act or any other law. 2. Disclosure is necessary for purposes of carrying out the provisions of the Children's Act. 3. Disclosure takes place for purposes of legal proceedings. Or 4. Disclosure is made in terms of a court order. See 241. Minors below the age of 12 years require the consent of their guardian to obtain contraceptives. See 242. The Children's Act does not provide for those cases in which consent is withheld. However, in its capacity as upper guardian of all minors, the High Court has the power to dispense with consent should the minor's best interests require this. A minor who has turned 12 may independently buy condoms and receive free condoms on request. See 243. He or she may also be provided with other contraceptives on request, provided that he or she receives proper medical advice and undergoes a medical examination to determine whether there are any medical reasons why a specific contraceptive should not be provided to him or her. See 244. A minor who obtains condoms, contraceptives, or contraceptive advice is entitled to confidentiality in this regard. See 245. 6.4.2 Capacity to hold certain offices and perform certain functions. On the ground of his or her minority, a person who is below 18 years of age is incompetent to perform certain functions and to hold certain offices. For example, a minor cannot be a director of a company or mutual bank. See both 246 and 247. Whether a minor can be the executor of a deceased estate has not been finally settled, but it is submitted that he or she cannot. See 248. As emancipation does not terminate minority, an emancipated minor should be disqualified from holding these positions. But a minor who has attained majority status through entering into marriage should not be disqualified. See footnotes 249 and 250. A married parent who is younger than 18 years qualifies as his or her child's guardian. C 252, but cannot be appointed as the guardian of somebody other than his or her child. C 253. The same applies to an unmarried parent who is younger than 18 years and has obtained guardianship in respect of his or her child in terms of the Children's Act. C 254. A minor can act as someone's agent without the consent of his or her guardian, since an agent does not bind himself or herself, but instead binds his or her principal. See footnote 255. 6.4.3 Capacity to litigate. Generally speaking, a minor has limited locus standi in judicio in civil proceedings. The minor's guardian may either sue or be sued on the minor's behalf, or the minor may sue or be sued in his or her own name with his or her guardian's assistance. C 256. As is the case in respect of capacity to act, the guardian's assistance may be given by way of ratification. C 257. If the minor does not have a guardian, a curator ad litem is usually appointed to assist the minor. C 258. In Vista University, Bloemfontein Campus versus Student Representative Council, Vista University, the High Court relied on its powers as upper guardian of all minors and itself assisted the minors in the particular litigation. See footnote 259. In some civil cases, a minor may litigate without assistance. For example, if the High Court grants the minor venia agendi, that is, permission to conduct litigation, the minor is treated like a major for purposes of the particular proceedings. C 260. Other exceptions relate to maintenance claims against the minor in the maintenance court, an application to court for consent to marry without the consent of the minor's guardian, and certain election disputes. C 261. In criminal proceedings, the guardian's assistance is not needed. If a court makes a costs order against a minor, it is normally the minor who is liable. In exceptional instances, the court may order the minor's guardian to pay the costs either alone or jointly and severally with the minor. Such an order may be made if the guardian instituted or defended the litigation frivolously or recklessly, or allowed the minor to do so, or if the guardian acted in a malified, unreasonable, or negligent manner in respect of instituting or defending the litigation. C 262. Just to add on to the definition of malified, in law, the term malified is a Latin phrase meaning in bad faith, in quotes. So it describes an action or intent that is dishonest, fraudulent, deceptive, or made with an improper, ill will, or selfish motive. 6.4.4 Capacity to incur delictual and criminal liability. To incur delictual or criminal liability, the minor must be accountable. A person is accountable only if he or she has the mental ability to distinguish right from wrong and to act accordingly. C 263. In terms of the common law, It is rebuttably presumed that minors between the ages of 7 years and puberty, 14 years for boys and 12 years for girls, are not accountable for their delicts. Read 264. Boys between 14 and 18 years of age and girls between 12 and 18 years of age are rebuttably presumed to be delictually accountable. See 265. In other words, they are considered accountable until the opposite is proved. The different ages at which boys and girls are presumed to acquire the capacity to be delictually accountable may well amount to unjustifiable sex discrimination. See 266. If the minor's guardian uses the minor as his or her agent or instrument, or negligently fails to prevent the minor from causing damage, the guardian may be held personally liable for damage the minor causes. See 267. If the guardian employs the minor, he or she can also incur vicarious liability for delicts the minor commits in the course of his or her employment. See 268. A minor's capacity to be held criminally accountable is governed by the Child Justice Act 75 of 2008. In terms of the Act, the minimum age for criminal accountability is 10 years. In other words, a minor below the age of 10 years cannot be held accountable for any crime he or she commits. See 269. A child between 10 and 14 years of age is presumed to be criminally unaccountable. See 270. Such a child has criminal capacity only if the state proves beyond reasonable doubt that when the alleged crime was committed, the child had the capacity to understand the difference between right and wrong and to act in accordance with that understanding. See 271. A minor over the age of 14 is criminally accountable in the same way as an adult. See 272. When the Child Justice Amendment Act 28 of 2019 comes into operation, the minimum age for criminal accountability will be raised to 12 years, and a child between 12 and 14 years of age will be presumed to be criminally unaccountable. 6273. 6.5. Termination of minority. 6.5.1. Attainment of the prescribed age. On the 1st of July 2007, Section 17 of the Children's Act lowered the age of majority from 21 to 18 years of age. See 275. Because the Act does not operate retroactively, the lowering of the age of majority did not retroactively affect rights that vested in or accrued to a person who was below the age of 21 years before the 1st of July 2007. Thus, for example, if a person who was below the age of 21 years obtained a claim before the 1st of July 2007, he or she is treated as a minor for the purposes of establishing whether extensive prescription has taken place in respect of the claim, despite the fact that the Children's Act lowered the age of majority. In terms of the Prescription Act 68 of 1969, prescription usually takes place 3 years after the date on which the claim arises, but in the case of a minor, completion of prescription is delayed until at least a year after the minor becomes a major. See footnote 276. Prior to the 1st of July 2007, this meant that completion of the prescription period was postponed until at least 1 year after the minor turned 21. In Malcolm versus Premier, Western Cape Government NO, see footnote 277, the Supreme Court of Appeal held that, if anything, the fact that the Children's Act is silent on the effect of the lowering of age of majority on prescription points to the change in the law operating only in cases arising after the 1st of July 2007. So just to quickly add there, for someone who might be interested, what the NO after Western Cape Government stands for, in the South African Supreme Court of Appeal case, Malcolm versus Premier, the one that is mentioned here, the term no, or the word NO, refers to the word NO, which is a Latin abbreviation meaning no office. So that indicates that the Premier is being sued in their official capacity as the head of the Western Cape government rather than as a private individual. So that's what that means. The Supreme Court of Appeal pointed out that persons who were over the age of 18 when Section 17 came into operation attained majority on 1st of July 2007, even though they had actually turned 18 before that date. For this reason, contracts they had entered into without the required assistance before the 1st of July did not automatically become enforceable against them on the 1st of July. Nor did marriages they had entered into without the requisite assistance before that date suddenly become valid. There was no reason why the position in relation to prescription should be any different. The court further held that hardship would arise if the lowering of the age of majority were retroactively to affect the rule regarding extensive prescription of minors' claims. The court therefore concluded that lowering of the age of majority did not affect periods of prescription that were running before Section 17 came into operation. See footnote 278. In Apdol versus Road Accident Fund, C279, the High Court had earlier arrived at a similar conclusion in respect of prescription of a minor's claim in terms of the Road Accident Fund Act 56 of 1996. In terms of this act, too, prescription of a claim usually takes place 3 years after the date on which the claim arises. C280. However, in the case of a claim by a minor, prescription only starts to run once the minor becomes a major. C281. The court held that the lowering of the age of majority did not affect any right a minor acquired before the age of majority was lowered to 18 years. Majority ensues at the beginning of the day of the person's 18th birthday, unless it is to his or her advantage to prolong minority until the precise moment that corresponds to the time of his or her birth. C282. It is doubted whether the exception is ever applied in practice. 6.5.2 Marriage. A person who enters into a valid civil or customary marriage before turning 18 thereby becomes a major for all purposes. If the marriage is dissolved by death or divorce before the person reaches the age of 18 years, his or her minority does not revive. C283. A void marriage does not terminate minority, and the annulment of a voidable marriage restores a minor's limited capacity with retroactive effect. C284. The Civil Union Act restricts civil unions to persons who have already reached the age of 18 years. See 285. Thus, a minor cannot acquire majority status by entering into a civil union. 6.5.3 Venire aetitis and release from tutelage. At common law, the sovereign, that is the head of state, could grant a minor a concession to act as a major. This was known as venire aetitis. The effect of venire aetitis was to make the minor a major in the eyes of the law, with the exception that he or she could not alienate immovable property or burden it with a mortgage unless this capacity was expressly conferred to him or her. See 286. In South African law, venire aetitis was granted in the Free State, where it was governed by statute and granted by the state president by proclamation in the Government Gazette after the Supreme Court had recommended it. See 287. Although the legislature had not repealed venire aetitis and our courts have not expressly decided whether venire aetitis is obsolete, it is clear that no administrative machinery has existed for dealing with it for some time. See 288. It is therefore submitted that venire aetitis can no longer be granted. See 289. In the past, the Cape Courts were willing to grant an order releasing a minor from tutelage. See footnote 290. So this might still be explained to us, but just for carrying on, let's define what tutelage means. So here it says, in law, tutelage is a form of legal guardianship where one person, the tutor, in brackets, protects, guides, and oversees another person, the ward, in brackets, who is incapable of managing their own affairs, particularly for legal purposes or financial interests. It also carries on to say, the term also refers to the state of being under a guardian's control or care. Even though such an order had more or less the same practical effect as venire aetitis, it was held that the court was actually merely emancipating the minor in its capacity as upper guard of all minors. See 291. Today, in its capacity as upper guardian of all minors, the High Court might still be willing to release a minor from all or some of the parental responsibilities and rights his or her parents have in respect of him or her. In this sense, so-called release from tutelage, in quotes, might still be possible. It has to be borne in mind, though, that Section 8 of the Children's Act empowers the High Court, a regional court dealing with the divorce matter, and the Children's Court within whose area of jurisdiction the child ordinarily resides, to terminate, suspend, or circumscribe a person's parental responsibilities and rights. See footnote 292. With the court's permission, an application for such termination, suspension, or circumscription may be made by the child in respect of whom the parental responsibilities and rights operate. See 293. In future, the judicial power embodied in Section 28 may well, in practice, replace release from tutelage, in quotes, should the latter mechanism still exist in our law. See 294. 6.5.4 Emancipation. A minor is emancipated if his or her guardian grants him or her freedom independently to enter into contracts. See 295. This occurs, for example, where the minor participates in a commercial enterprise as an economically independent person. Emancipation can be compared to the situation where a minor performs a valid juristic act with the assistance of his or her guardian. In the latter instance, the guardian consents to a specific act, whereas in the case of emancipation, the guardian consents to a range of juristic acts falling within a particular sphere. Whenever such consent is given, the minor incurs liability just like a major. Either parent may emancipate the child, provided that the parent has guardianship of the child. See footnote 296. Whether a minor is emancipated if one guardian emancipates the minor while the other refuses to allow the minor to be emancipated is unclear. If a minor has no parents, the minor's legal guardian may emancipate the minor. See 297. Emancipation can only be affected by express or implied consent. Mere carelessness on the part of the guardian does not result in the minor's emancipation. See 298. Whether or not a minor has been emancipated is a question of fact, which the court must decide upon after considering all the circumstances of the case. That the minor lives on his or her own and manages his or her own business are mere factual details, together with others such as the minor's age, the relationship between the minor and the guardian, the nature of the minor's occupation, and the length of time for which the occupation has been carried on, help to establish whether emancipation has in fact taken place. See 299. If the minor lives with his or her guardian rather than on his or her own, stronger evidence will be required to prove emancipation. See footnote 300. The onus of proving emancipation rests upon the person who alleges that it has taken place. See 301. It is unclear whether a guardian who emancipated a minor may later revoke the emancipation. Obiter dicta in Cohen versus Steintner and Landman versus Mini, C303, support the view that emancipation is irrevocable. The better view is that the guardian is entitled to revoke the emancipation. See 304. The question of the effect of emancipation on the minor's capacity to act has not been authoritatively decided. The issue is whether emancipation applies only to transactions in connection with, for example, the minor's business, or whether the minor may act beyond the scope of that business. Some cases are authority for the view that emancipation gives the minor capacity to act in respect of all contracts, except that the minor may not alienate or encumber immovable property or marry without his or her guardian's consent. See footnotes 304 and 305. In other cases, it was held that the minor is emancipated only with regard to contracts in connection with his or her particular business. See 307. It seems, however, that in this respect, the courts have confused two common law institutions, namely tacit emancipation and general authority. At common law, tacit emancipation terminated minority, C308, while general authority was no more than advance consent to enter into transactions of a certain kind, had no effect on the parental power, and could be revoked at will. See 309. Be that as it may, it is submitted that as far as modern practice is concerned, the degree of legal independence a minor has acquired is a question of fact that depends on all the circumstances of the case. If the minor has given complete freedom of action with regard to his mode of living and earning his livelihood, in quotes, C 310, the minor is emancipated for all purposes except alienation or encumbrance of immovable property and marriage. In contrast, the minor's capacity to act is restricted to matters connected to his or her business if his or her guardian has emancipated him or her for purposes of that particular business without otherwise having relinquished parental responsibilities and rights. See footnote 311. It was submitted above in this chapter that sint restitutio in integram is available to a minor who concluded a prejudicial contract with his or her guardian's consent, there is no reason why it should not also be available to an emancipated minor. The courts seem to assume that an emancipated minor has locus standi in judicio. See footnote 312. However, it is doubted whether this assumption is correct. A guardian who consents to a minor's entering into a specific individual transaction does not automatically also consent to the minors engaging in litigation regarding that transaction. It therefore seems inaccurate to assume that a minor who has been emancipated automatically has locus standi in judicio in respect of all matters falling within the sphere of the transaction to which his or her emancipation relates. See footnote 313. Whether the rules regarding emancipation will remain relevant remains to be seen, because the lowering of the age of majority will probably reduce the number of cases where emancipation is at issue. See 314. And with that, we come to the end of chapter 6. And what we can look forward to on chapter 7 is our topic on mental illness. Hey there, thank you for listening. If this was helpful to you, please take a minute to subscribe, like, comment, and share.